early and medieval India. Such writing as is available for this period focuses overwhelmingly on women's subjugation and on their assertions across caste, class, and social location against traditions of orthodoxy. Focusing on the preoccupation with sexual control of women in early Hindu society, Uma Chakravarti, whose stellar work, in fact, guides us all the time, argues that the purity of women was constitutive of Brahminical patriarchy and of the caste order. And any nonconformism to rigidly sexualized codes by women threatened the property and status order and was therefore reined in by elaborate law codes enforced by the state. Chakravarti suggests that from sparse historical evidence available, it can be reasonably inferred that prehistoric cultures in the region did point to women's active engagement in productive and reproductive activities with no rigid sexual division of labor. Drawing a distinction between gender in early Indian history and the histories of women, so you're drawing a distinction between gender and the history of women, Kumkum Roy, again, presents a finely calibrated account of the layered gender archives on the Indian subcontinent through an examination of Brahminical, Buddhist, Jaina texts and traditions drawing on Sanskrit, Pali, Prakrit, and other languages. And she plots a complex terrain where the representation of women who stayed at the home as a mark of male status coexisted with not infrequent references to women who worked outdoors, and so on. Vijaya Ramaswamy's work on 12th century South India points in a similar direction. Veerashaivism, her research reveals, made space for women's self-expression and spirituality in unparalleled ways. And this is an important idea and thought for us to work through, especially at a time when faith and spirituality are completely being captured within a very misogynist orthodox framework. Her research reveals that the self-expression and spirituality of women opened out the possibility of interrogating established norms of conjugality and presenting a dual defiance, a defiance of the Brahminical system as well as of the patriarchal structure. And she adds a layer to this by looking at 3 levels of interplay between gender and spirituality, leading finally to salvation through sexual sublimation, through androgynous transvestitism, and through finally taking on an asexual form of sexual transcendence. On the question of gender definitions within the binary sexual framework, which determined entry into the Buddhist order, there was a recognition of intermediate groups in early Buddhist traditions. Jaina texts presented a more complicated picture and a more complicated debate, where misogyny coexisted with a recognition of the fluidity of gender identities. And I have Zwilling and Sweet's work in mind here. Ramaswamy's work on the Tamil Mahabharatas, likewise, suggests that critical editions authored by men tended to freeze women within certain descriptive and prescriptive frames contained within the Sanskritic, Brahminical, and patriarchal register. A close reading, on the contrary, reveals that Tamil Mahabharatas, whether as textual fragments or as performances, break caste and gender barriers in significant ways, marking a departure from the Sanskrit Mahabharata epic. So there is no one Mahabharata, no one Ayodhya, as Kamal Khan showed us on NDTV the other day. In their manifold forms, they represent different strokes in the Brahminical patriarchal narration, unquote. How might we begin to historicize, then, gendered states in India? What is a question, this is a question that is of utmost importance today, but one that I will not have any time to dwell on at any length. Suffice it to say that gender disrupts the stable zone of dominant assemblages at different levels. Raven Connell's early theorizing of the state and sexual politics is a wayfinder. namely the state and gender relations, are co-constitutive of each other historically and in the present time, and cannot be understood independently of each other. At the empirical level, therefore, the gender order is reflected in distinct gender regimes that characterize distinct state formations. Cynthia Enlow's insistence on a gender-curious investigation that is focused on laying bare the workings of a heterosexualized masculinity as a bulwark of a militarized political state helps us to disaggregate state practice and disengage its gendered terrains in ways that illuminate the possibilities of a constitutional understanding of equality that is inclusive, and not the jingoistic understanding of state power that we are witness to in the everyday today. Feminist analysis, therefore, helps us understand the specific deployments of state power, nationally and internationally. And it helps us to see the close interconnections between the national and the international, and helps us to come to grips with the complexity of the embeddedness of gender power and rule-making in the routine everyday and in the heightened exception. Constructions of masculinity and femininity lie at the core and are constitutive of the familial, the social, the political, and the judicial, as we have long argued, and bestow legitimacy on a range of masculine moves across and between these domains. It is only through an investigation that is nuanced and takes this into account, therefore, that we are fully able to even imagine a cogent challenge to unlawful state action and the absence of due diligence by the state in the private, closed spaces of family, caste, tribe, community, and kin networks. The challenge to impunity at each of these levels lies at the heart of our understanding of equality. And my older argument bears reiteration that we cannot understand the idea of equality if we don't first begin to understand the intersecting realities of equality and liberty. How then do we look at these unique historical assemblages of gender in different historical contexts, in different historical periods within the same region, and in a comparative analysis of different regions? We are at a historical moment that encloses the opening words of the preamble to the Indian Constitution, "We, the people of India," into a deeply gendered Hindu nationalist rendering of nationhood and citizenship. It is therefore, and we have seen this increasingly since 2019 when the Citizenship Amendment Act was passed, it is therefore important to recall that the drafting committee of the Constitution was especially mindful of the treacherous enclosures of caste Hindu society, fueled by religious orthodoxy that reduced entire peoples to servitude, serfdom, and indignity. This resistance that Dr. Ambedkar brought to bear on the task of drafting the Constitution had a long history that, again, I can only signpost today. Suffice it to say at this point that in resisting Hindu Samaj and Hindu social order, Dr. Ambedkar garnered arguments and reason from different quarters and different intellectual traditions to construct an imagination of equality, dignity, and fellowship. Fraternity is the term he used, for a future that could then strike a path that is not blocked by the palace on the dung heap, to use his words. His philosophy of Navayana Buddhism and his delineation of the purpose of conversion, for instance, effectively confronted what Warren calls ontological terror of a Hindu majoritarian caste society through an elaboration of questions of liberty, equality, fraternity, justice, and democracy, constitutional morality, in other words, and an interpretation of precepts that lifted religion out of the morass of dead habit or blind faith, a reified essence, situating it instead in a robust and dialogic social context tethered to reason. And I have in mind here the work of Akash Rathod and Verma. The 22 vows scripted by Ambedkar that they talk about to mark his conversion entwine the hermeneutic principles of the Constitution as he saw it with those of ethical belief and faith. The avowed rejection of inequality and the vow to establish equality and compassion led him to renounce Hinduism and Hindu gods and to follow the Noble Eightfold Path of the Buddha. Ambedkar's use of the term assembly plant to describe the Buddha and his Dhamma is important, a cognizant and purposive building of an archive of resistance rooted in the deep spirituality of fellowship, fraternity, and compassion that provided a moral basis to confront Hindu society, but more importantly, to organize society on terms that were radically different. 4 decades or so before Ambedkar published the Buddha and his Dhamma, Ayodhi Das mobilized anti-caste resistance in Madras presidency by renotating Panchamar to mean the followers of the 5 Buddhist principles and spearheading the Tamil Buddhist movement's efforts to historicize untouchability by locating, I quote, the rivalry between Parayars and Brahmins as actually a rivalry between Buddhism and Brahmanism, to quote from the work of Ayyadurai. In producing a counter-narrative of their own cultural and religious history, Ayyadurai points to the ways in which the Parayars, who considered themselves caste-free, I quote, refashioned their sense of India as a Buddhist nation and their antiquity as Indian and Tamil Buddhists in contrast to the upper caste Hindu view of India. Through his efforts at crafting an intellectual debate, through his publication, The Tamilan, and through the various Buddhist forums he founded or was part of, and also through lobbying with the colonial government to get Buddhists listed separately in the 1911 census, Ayodhi Das, I quote, made a valiant attempt to rework the self-identification of the oppressed that would transcend caste. It is these cascading histories of anti-caste resistance and their articulations of personhood, the spirit of dignity, fellowship, self-respect, mutual understanding, and ethical belief that we must reinstate in our present. The recall of conversion histories and the deep diversities in religious practice is especially critical to destabilize the ontologies of monolithic Brahminical Hinduism as the normal cultural discursive setting for the juridicalization of rights, especially where women, Hindu and non-Hindu, are concerned. We encounter 2 phases of this juridicalization of women's rights in family and community. Both relate to Muslim women. The first, where the figure of the Muslim woman triggers an acontextual reading of verse in Sanskrit in ways that diverse Sanskrit of its history and context and refuse its grounding in normal citational protocols. Sanskrit in Devanagari and or Roman encodes the Indian and marks the other. And we see this in the judgments of the Supreme Court in the cases of Shah Banu, Zahira Sheikh, and Shara Banu. The second is the spectral figure of the Hindu woman who converts to Islam and exposes a judicial and governmental animus towards conversion from Hinduism, the opposite route never actually being the subject of judicial deliberation. The Hadia case, for instance. The renewed hysteria around the criminalization of inter-community choice marriages from ordinances in states like Uttar Pradesh and Madhya Pradesh that prohibit unlawful religious conversions via love jihads to the brutal honor crime and hacking to death of an intercaste couple in broad daylight in states like Tamil Nadu that have not had these crimes reported before reminds us that these are not isolated events, but rather a new form of culturally constructed logics. of consent. These references to conversion and judicial appropriation of the Hindu caste normal as the habitus for the constitution necessitates a discussion on minorities and majoritarianism, especially in terms of its implications for constitutional justice, especially in the case of equal rights for women across community and caste. With Ambedkar clearing a path, how do we understand the question of minorities? As Rowena Robinson argues, and I quote, the institutionalization of minority rights in India was coeval with the constitution of the nation state. Unquote. The focus on majority-minority dichotomy with special reference to Hindus and Muslims as bounded and undifferentiated communities needs to be historicized. Articles 25 to 29 of the Indian Constitution set out the basis for cultural rights of communities, and Article 30 of the Constitution sets out protections for the educational rights of minorities. The freedom of religion and conscience set out in Article 25(1) is as follows, I quote, subject to public order, morality, and health, and to other provisions of this part, all persons are equally entitled to the freedom of conscience and the right to freely profess, practice, and propagate religion. Despite this, the discussion fueled by Hindutva political forces on forced conversion and the staging of a threat to the demographic preponderance of Hindus is one that has percolated into judicial habitations from political and legislative ones. Anti-conversion laws are in force in 9 states in the country: Arunachal Pradesh, Orissa, Madhya Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, and Uttarakhand. The demographics, according to the census of 2011, are as follows: Hindus 79.8%, Muslims 14.3%, Christian 2.3%, Sikh 1.2%, Buddhist 0.7%, and Jain 0.37%, and Parsis 0.016%. The primary targets of anti-conversion laws in the states have been Muslims and Christians, and the laws in some states make an express distinction between conversion implicitly from Hindu to other religion and reconversion from other religion to the religion of their forefathers. As Rajshri Chandra points out, the common thread that runs through these legislations is that use of force, allurement, inducement, and fraud in securing religious conversions is a cognizable offense and punishable by law. A closer look at the statutes reveals that in Rajasthan, Arunachal, and Chhattisgarh, the definition of conversion explicitly excludes reconversion to native faiths. So there isn't a one-size-fits-all, even within the anti-conversion rhetoric. With respect to the conversion to Christianity, it is instructive to go back into history. Sundar Bhupalan observes that the translation of the Bible to vernacular languages saw many Dalits embracing Christian scripture, which for them was a move to approximate spirituality and literacy that was denied to them under Hinduism. More recently, we have seen the conversion of Dalits into Islam in Tamil Nadu. Historian Sanal Mohan's poignant account in his 2015 book of Lucy's conversion spins the caste gender complex to the center of our consideration of the idea of intersectionality, bringing together Lucy's simultaneous location in transnational contexts, the missionary and the slave trade, within the Hindu caste order's practices of slavery, and in the liberatory context of conversion of Dalit women. I quote from Sanal Mohan: Kali was purchased by a European gentleman in 1827 and was supposed to accompany him and his family to Java. She pleaded to the missionaries in Cochin to let her into the mission compound where she had reached from her hideout, since she did not want to leave her land forever. She was then baptized as Lucy. This was a woman who was sold. Yeah. She was then baptized as Lucy in 1828, who, according to the missionaries, continued to grow in grace. The reconversion, anti-conversion politics that mediates discussions and litigation on minority rights in India today draw from and feed into stereotyping, securitizing, and demonizing discourses on minorities, closely tied to the condonation of hate crime and incitement to anti-minority violence. But there are more insidious functions that stereotyping performs. Robinson draws on Iris Young and outlines the processes of stigmatizing and stereotyping as, I quote, the worldview and experience of the dominant group that gets projected as the norm. Its values and goals, even its history and culture, are the most widely disseminated in society. As a result of which, I quote, the perspectives of other groups are understood in terms of deficiency and negation. These groups are viewed as lacking or falling short of dominant ideals and ethos, and find themselves positioned outside the pale of dominant meanings and structures of experience, unquote. This is a short step from demonization and securitization that sees the minority constructed as a danger to society and the polity, the discourse on the anti-national, the deployment of carcerality as governance in the context of protests led by Muslims against the Citizenship Amendment Act 2019, and the military occupation of Kashmir are a demonstration of the derogation of minority rights by juridicalization, legislation, and governance. And the gendered implications of carceral rule and state practice is tied to various factors that impact on the everyday lives of women across the country. The constituents of religious groups and the flow of constitutional protections, including, importantly, the protection of equality along these religious lines, complicates our understanding of minority rights. With scheduled tribes, for instance, the picture is distinctive. As Dr. Jaipal Singh Munda asserted tirelessly, I quote, Adivasis have their own aboriginal pre-Aryan religion, which cannot be called Hinduism by any stretch of imagination, unquote. Dalit rights present a major concern in constitutional interpretation and claims to protection on caste atrocity, especially. While the statutory and constitutional protections to scheduled castes are available to those who identify as Hindu, Buddhist, or Sikh, the same is not the case with Dalit Christians and Muslims, thus splintering the category of the scheduled castes. Further, the rhetorical and statutory enfolding of the Buddhist with the Hindu runs completely contrary to the conversions into Buddhism as a political move out of the enclosures of Hinduism that we see historically. We have Dr. Ambedkar and we have Ayodhi Das before him. And also importantly, in the case of the Dalit Buddhist resistance in the 19th and 20th centuries. Our interest, therefore, lies in exploring the gendered ways in which discussions about differentiated citizenship, and this is extremely important. It is a term Rajiv Bhargava introduces. Discussions about differentiated citizenship, dignity, empathy, personal liberty, and so on may be opened out. And deliberations on the rights of minorities that shape the Constitution and that are imperiled today must be understood within larger contexts where minorities within the Constituent Assembly, while they refer to religious minorities, also refer to others, scheduled castes and scheduled tribes notably. And there are four figures who are extremely important to our understanding of this debate. Because equality on the basis of gender or equality for women is never comprehended in terms of the isolated experience of women alone, because there is no isolated category of women that we can speak of. Dr. Ambedkar, Maulana Abul Kalam Azad, Dr. Jaipal Singh Munda, and Srimati Dakshayani Velayudan are four figures who are extremely important to our understanding of the Constitution. In his work on the framing of the Indian Constitution, Shivarao records, and I quote, that Ambedkar had an interesting suggestion to make. The candidates belonging to a majority community should, before being declared elected, poll a minimum number of votes from among the minority communities in their constituencies. This would have amounted to a minority exercising a sort of veto on majority communities. And I think it's not a bad idea to take this idea of Ambedkar into the coming elections in the various states, notably Uttar Pradesh. In other words, what Ambedkar suggested, and his was the lone voice, was a cumulative minority referendum on the majority candidate in every constituency. And this was in the immediate aftermath of the 1947 partition. Abul Kalam Azad, as Saida Hamid points out, placed Hindu-Muslim unity before Swaraj. In thinking through the rights of minorities on the eve of partition, he seemed to anticipate Dr. Ambedkar's idea on the right to veto when in 1940 he declared, and I quote, any constitution that is framed in future for India must contain the fullest guarantees for the protection of the rights and interests of minorities. What are the necessary safeguards? This judgment rests with the minority, not with the majority, and therefore must be formulated by their consent, not by majority vote, unquote. Shona Rodrigues traces the ways in which Azad reinscribed the boundaries of the political, challenged British imperialism, and articulated, I quote, articulated ethical, moral, and theological arguments emerging from, among other sources of Indian tradition, Islam, on the nature, justification, and critique of a unified rule of law for a diverse people, unquote. In doing this, he pointed to the plural foundations of self-rule and the rule of law in independent India that played a constitutive role in the framing of the constitution and in the framing of the idea of equality that we have with us today. Jaipal Singh Munda drew on the Adivasi experience of colonial and majoritarian subjugation in his definition of self-rule. I quote, the new constitution will be judged not by the provisions for minorities, but by the way these are worked to their best advantage. And Dakshayani Velayudan, the only Dalit woman in the Constituent Assembly, came into the drafting process with experiences of resisting untouchability and marked the ways in which suffering resilience and resistance of Dalits made the Constitution what it is. In her recent work on birthright citizens, called Birthright Citizens, legal historian Martha Jones argues that citizenship is distinct from and deeper than political rights to voting alone, and is embedded in birthright, as African Americans argued long before they belonged equally in the Constitution. While race genealogies in the US do not have seamless extensions outside the country's context, Jones's argument still prompts us to ask what such a birthright might be in our own contexts. She observes pertinently, I quote, sometimes citizenship was defined in constitutions and statutes. Most of the time, it was not. Similarly, with equality, has equality been defined in the Indian Constitution? Or is it up to us, taking account of this long and diverse and plural history, to define what equality in fact means, not abdicating the definition of equality to our courts and judges alone? We ask how our own ideas of citizenship test the borders of belonging or definitions of equality. I move from here to looking particularly at Article 17, and it will soon be clear why I am looking at Article 17, which is the ban, the constitutional ban on untouchability. Professor Gopal Guru urges us to look at the idea of self-determination in situated ways. Does it refer to self-rule, or does it mean self-respect, which inflects self-rule in a radically different way? For Dalit Bahujan leaders, he points out, the struggle for social justice was interlocked with the nationalist struggle, so that nationalism itself meant a nation without any kind of natural or inherited discrimination between human beings. An imagination that blended legal and moral rights of citizenship, a utopic possibility that is only as within reach as it is surreal. Drawing an important distinction between positional good and cultural good, he points to the relative ease of achieving positional good through reservations, for instance, but the difficulties in translating this into the cultural good embodied in the ideas of dignity and recognition, what Dr. Ambedkar denotes as a one man, one value precondition to justice. In order for the Constitution to move to a position of guaranteeing cultural justice and substantive equality, I quote Gopal Guru, it has to augment its extractive power to force non-Dalits to acknowledge the achievements of Dalits. Dr. Ambedkar's effort, in Guru's view, was to make the moral good, that is dignity and recognition, a meta-evaluative concept. And it is these learnings and this wisdom that must then inform our idea of equality as a concept that can only be understood in intersectional terms historically, and intersectional terms at a single point of time within diverse and plural traditions. He also traces the epistemic limits of Article 17, the constitutional ban on untouchability, and observes that this provision in its deployment of untouchability as a classificatory criterion assumes that it is located in the untouchable body, which is then the object of restraint. Yet, till the truth of untouchability remains, he says, remains located, the truth of untouchability, in fact, remains located in the sacred body of the touchable, a reference that only exists in contrast. The upper castes have the ritual power to define who is touchable and untouchable. And I'm quoting him. It is he who marks the purity pollution line. He is the cartographer who is ritually empowered to demarcate conceptual spaces and confine some people within those spaces. It is he who is in possession of the power of touch that he deploys to assign hierarchical meanings to the human body. In a kind of peculiar inversion, one finds a touchable rendering himself supra-untouchable. Nobody can touch him. So touch is, in some sense, a problem for the touchable as well. It is the touchable who takes all the precautions, because touch could be the source of anxiety in relatively anonymous locations due to blurring social morphology that have become sociologically quite ambivalent. Now, this idea of the relationship between the touchable and the untouchable is not something that we learn in the normal course in sociology. The reason why this is relevant today, and the reason why I am referring to it specifically in this talk, is that focusing on the upper caste body, the touchable body, which in fact inscribes territories and bodies of untouchability and touchability, illuminates our understanding of the Sabarimala case and women's temple entry. Menstrual taboos in places of worship have had a long and uninterrupted reign, especially in Hindu temples of different orders, bleeding into Muslim and Christian places of worship on the subcontinent as well. The other illustration is the prohibition of women barbers in Tirupati, using the argument that women who menstruate will pollute devotees. The labor of depilation itself is classified as polluting in the grammar of caste. And therefore, it is ironic the insistence on pure female bodies to perform a defiling chore is itself ironic. In the light of Gopal Guru's argument on the legibility of the touchable body that prescribes untouchability, even in this case of a gendered proscription, that is women's temple entry, untouchability is mapped onto the female Hindu body. The Hindu male is still supra untouchable, and the anxiety of defilement is the anxiety of the male Hindu body mapped onto the celibate homosocial deity. If the sexualness of a woman across caste barriers, connoted by her capacity to menstruate and thereby render the deity vulnerable to seduction, is the ground on which she is rendered untouchable, what does this tell us about the ways in which caste ways constitute the roadblocks to constitutional socialities that must be based on the idea of equality? This was in fact the case in the Sabarimala Review. Extending this further, what are the ways in which the aggravated vulnerability and discrimination is rhetorically read down by courts within the meanings of dominance and training the focus on vulnerability and victimhood in need of saving, instead of looking at the ideological underpinnings of such exclusions that we have considerable theorizing on. Finally, a word on the diaspora. Savarna men and women in the South Asian diaspora in the US appropriated a racialized identity to claim kinship on the basis of whiteness or Aryan blood, and discrimination against Dalit South Asians in the United States within the South Asian immigrant community is commonplace. The Equality Lab's report on caste in the US points to the historical emergence of the racialization of caste by the early 20th century Hindu diaspora. And I have in mind here the work of Zvik Maitreyi et al. The failure by South Asians to meet the standards of whiteness set out in the Immigration Act of 1924, according to this report of the Equality Labs, led to Indian men challenging their exclusion in immigration courts. And I quote, "The first cases were brought by upper caste immigrants, A.K. Majumdar and Bhagat Singh Thind, both of whom argued that they passed the whiteness test because they identified themselves as high caste Hindu of full Indian blood. They then explained that because they were upper caste, they had pure Aryan blood, and that those racial origins were something that they historically shared with Caucasians." Unquote. Majumdar was granted citizenship on that basis. This was 1924, after the publication of Dr. Ambedkar's Castes in India in 1917. Dr. Ambedkar, in introducing the draft constitution in the Constituent Assembly, made a powerful reference to constitutional morality, marking it as a basis for a democratic and peaceful body politic. Although he did not elaborate on the idea at any length, he marked a distinction between constitutional morality and public morality, the latter containing incrustations of habits of discrimination and oppression that the Constitution sought to displace and uproot. Opening out the discussion on discrimination with a reference to constitutional morality immediately foregrounds the praxeological possibilities of the concept of intersectionality. The resurrection of the constitutional morality, of the term constitutional morality, after a hiatus of 6 decades, was occasioned, importantly, by the decision of the Delhi High Court in the case of Naz Foundation versus NCT Delhi. which decriminalized homosexuality in 2009, deploying, among other arguments, Article 15.1 of the Constitution of India to rule that the ground of sex included sexual orientation and that exclusion of sexual minorities from places of public resort through the criminalization of consensual intimacies, orientation, and diverse gender identities was violative of Article 15.2 of the Constitution. At the time of its drafting, Article 15.2 focused on practices of untouchability and segregation of Dalits. In 2009, it is used to prohibit the segregation or ghettoization or stigmatization of sexual minorities and LGBTQI communities. 2 points are worth noting. First, that NAS Foundation removes considerations of gender from a heterosexual binary construction to gender plural contexts. Second, fields of discrimination set out in the Constitution overlap and intersect, in a sense co-constituting each other, and may best be understood on those terms. In this case, the intersection is demonstrated through the grounds of sex and caste. There can be other grounds as well. How might the question of justice, of which equality is part, social, economic, and political, as guaranteed in the preamble to the Indian Constitution, be framed anew? How might this transgressive praxis open new ways of engaging from the margins and the borders across identities and locations? Intersectionality renders possible the reimagination of the citizenship question by taking note of the critical praxis of resistance that destabilizes the heteronorm and majoritarian dominance, the caste gender complex, if you like, with renewed vigor. And we perhaps need to revisit our understanding and our definitions of equality within this larger and extremely complex history of resistance that we are proud bearers of. Thank you.
Thank you, Professor Kannabiran, for an absolutely fabulous paper that you have read and shared with us, and for making some very important connections, drawing our attention to some very important dimensions, and of course for enriching our undergraduate students, sense of the literature and the critical scholarship on the questions of caste, but also gender, the constitution, and of course the fault lines. So we now open the floor for any questions, any comments. If there were certain arguments or observations that you seek more clarity about, then feel free to even, unmute and ask those kinds of questions. We also have some of the teachers, colleagues here who are advisors in the Women's Studies Center. Please feel free to unmute and share any comments or questions you may have. With Rose, also please check the YouTube because there are times comments put up there on the channel. Yes, Shagun, please go ahead.
Good afternoon, ma'am. That was a very insightful session. And I just wanted to ask you, as you mentioned, there was only one Dalit woman in the Constituent Assembly. And the things are not very open for women representation in Indian politics. They have 33% reservation, and the bill is also impending. So, what do you think is the current scenario about the representation, and what can be done for it?
Well, you've actually gone right to the heart of the matter. representation is indispensable, shall I say, to equal dignity and to autonomy. And I wouldn't only say women's representation, I would say gendered representation, that all constituencies are represented. Certainly in parliament, but the only place that we have representation is in the panchayat system. Not in parliament, not in the judiciary, and let's not forget the judiciary here. So it's both the parliament and the judiciary, particularly the constitutional courts, the high courts and the Supreme Court, where women's representation is abysmal. And of course with parliament. And it is a goal. It's been my goal for the past 30 years. I've been writing about women's representation in parliament. And the debate picks up a bit now and then it just dies down. I mean, there has to be a political movement for representation. Because what we are saying is also a gap between the participation and leadership of women in struggles. We saw that with the resistance to the Citizenship Amendment Act. We also saw it in the farmers' protest. There is a huge and significant participation of women and a leadership of women in struggles. But this is not something that mainstream political parties are willing to enter into at all. And so I think the question before us is, why are men in politics and men on benches so threatened by the possibility of women's representation and the possibility of representation across gender and sexual orientation? What is it that threatens the patriarchate, if you will, so much that it is blocked so consistently and so violently often, and in such a misogynist way, and that the exclusion is so blatant in its violation of constitutional tenets, and yet nobody seems to have a problem. None of the men in control seem to have any problem at all with derogating this very, very fundamental constitutional tenet. So there is obviously something very, very deeply disturbing about the idea of women sitting there, about the idea of women on benches. So it gives us a sense of the power we wield, and must then inform our stepped up struggles to actually get there. And what will it take for us to get there? Certainly not in my lifetime, but I hope in the lifetimes of all the students who are listening in.
Definitely, ma'am. Thank you.
So, Professor Kannabiran, I mean, since we were talking about, the politics of representation and formal representation in, elected bodies like the legislature, the Lok Sabha, etc. I just wanted to articulate one concern, which often, haunts one, especially when we are, participating in the activist movement, writing about these things, which is that, often, we've also been witnessing very clearly the trend in mainstream electoral politics, where we are seeing a lower caste elite, aligning with, upper caste, political platforms, parties, leaders, which, then also makes us question, that um, is it very often that, in the radical scholarship, including feminist scholarship, that there is a certain essentializing of caste that, is taking place, and how we need to factor in, that dimension about how it's, caste is, and gender is, of course, one reality, but so is, the intensifying class stratification and elite formation, within caste and within a category like gender, and how it plays itself out in everyday politics, in larger work relations, etc. So, what would your comments be on that?
Yeah, well, on political alignments, it's interesting that you refer specifically to, political alignments between the so-called lower castes and the so-called upper castes. There are political alignments of very many different kinds. This is only one. And so we don't really need to flag that, because you will have political alignments between the left and the right. You will have political alignments between the center and the right. You will have the seeping in of majoritarian discourse within so-called liberal political parties. So there are any number of permutations and combinations in mainstream politics. The low caste, the so-called, I don't like the use of the term low caste, but the so-called low caste alignment with the upper caste is only one. And it's not a it's not a generalizable phenomenon. It's not something that one can generalize about either across historical time or across region. It occurs in specific ways, in specific locales, driven by political expediency, which is what mainstream politics is all about. It is about political expediency. So that we've had perfectly, parties that we might have supported in the past that suddenly seem to align with majoritarian politics, or seem to adopt majoritarian practices within their politics to increase their voter base and so on. So I think it's part of that process. I think what we need to do, what we need to kind of separate from the account and look at separately is political expediency. What is it that drives political expediency, and how does that impact on the status and the claims of communities that are at the receiving end of majoritarianism, whether minority or Dalit or Adivasi. How does the alignment with a majoritarian party then defeat or whittle down claims to dignity and autonomy? So this can have many manifestations. It can have the manifestation of political formation of Dalits or the OBCs aligning with a right-wing party, or it can have the manifestation of individual political leaders from these communities working within a majoritarian party. But like I said, you will have any number of permutations and combinations that will work, in other ways as well. Class is, of course, a major factor, and I don't think when I talk about caste or caste or hegemony or domination, and or when I talk about intersectionality, I think class is and I would like to kind of reiterate that class is very much part of the measures of intersectionality that we look at. How does it complicate our understanding of social location? Does class in fact result in an upstaging of caste? Can it result in the upstaging of caste? These are questions that we must ask before us. We are a country that has seen two Dalit presidents. Yeah, we had President Narayanan and we have President Kovind. We have two Dalit presidents, and I would urge viewers to please look to watch the film India Untouched, and try and understand what I'm getting at about what I'm getting at when I say can class upstage caste. These are really very deep questions that haunt us. So if you ask me, irrespective of what political calculations drive alliances in electoral politics, I think the annihilation of caste is the first step towards a classless society. If at all we want to move towards a classless society, the annihilation of caste is the very, very first non-negotiable step. Because if you don't annihilate caste, you will still be a lower caste group aligning with an upper caste group. You will not be one political group aligning with another political group. You will continue to be a lower caste group aligning with an upper caste group. So it is only if you are able to move towards the annihilation of caste that you can then talk about convivial collaborations in very different terms.
Yes, Sandhya.
Good afternoon, ma'am. It was a very enlightening session. So, ma'am, you being a legal scholar, I had a question. So, with the rise of the Hindutva ideology in our country, we have this concern that, the people who might be in the government, they would want to implement, or there are talks about centering laws with the social laws of Manu, that is Manu Smriti. And as we see history, the laws are very discriminatory. So, ma'am, you being a legal scholar, what are your views upon this measure?
You know that Dr. Ambedkar burnt the Manusmriti, right?
Yes, ma'am.
That's my view.
Thank you, ma'am.
I am a follower of Dr. Ambedkar.
Professor Kannabiran, it was very interesting the way you unpacked, the Article 17 and the whole, way in which scholars like Gopal Guru and all look at untouchability and, how, the tensions within the Indian Constitution and how it was framed. And I just wanted to, also pitch in here and add on and get your comments, because this is something that we've actually discussed even earlier when we invited the Shini's daughter, Meera Vilayadyan, for a session. So we were looking at the formative phase and the constitution framing and certain articles. And it's this, it's how so many concerns and claims at the time, when the country had witnessed this huge freedom struggle, many other social movements. And then there is this, Constituent Assembly formed again on a property-based franchise election of 1946. And the way in which, the framework was negotiated, so many crucial claims, get pushed into the directive principles, the non-justiciable, segment of the Constitution. And so on so many fronts, while talking about minority rights, while talking about, discriminated, marginalized communities being guaranteed certain rights, there is this story to, the way in which a framework was thought out. So the postponement, and on all crucial issues like education, which is why we saw Right to Education Act only coming into the 2000s, so many decades after independence. So your comments on the other tensions in, the Constitution's framing and the debates there.
I mean, the assembly, the Constituent Assembly, was a very diverse set of people who came with very, very diverse politics and experiences. And of course, there were several issues, that were debated, and several thoughts, some of which are discussed, some of which are not discussed, like Dr. Ambedkar's idea of a minority veto. It's like it's brilliant. So what would happen to the UP election? Just think of it. What would happen to the UP election if we said all majority candidates must seek a minority veto? I mean, must seek a minority vote before they are declared elected. That there must be a minority referendum on every majority candidate. Can you imagine what would happen to Uttar Pradesh today? So I think that there are, now these, of course, don't find their way into enactments, but they are ideas, and they are ideas for a politics of the present. They are ideas on which we can build a politics of the future. And so to me, I look at the Constituent Assembly debates as, something that opens out several windows that it is for our generation and the generations after us to take ahead. Yeah. And as far as the tensions go, and there are very, very different ways of looking at the structure of the Constitution. On Article 17, it is unprecedented. Professor Upendra Bakshi has written extensively on this. It is possibly the only constitutional criminal provision anywhere. Constitutions don't have bans. Article 17 stands alone in that. And that is something that we have to be immensely proud of. That here is a right in the fundamental rights chapter, which is in fact a proscription of untouchability, no less. Yeah. And then, of course, you have the directive principles. And this has been an old debate within courts. And it was actually the invention of the courts. This is justiciable, this is not justiciable. No, there are rights that can be judicially enforced, and there are rights that are the political obligation of the state. So I don't see the directive principles as non-justiciable. I see them as state obligation, and they are politically enforceable. So there are judicially enforceable rights and there are politically enforceable rights. And the state bears a fiduciary responsibility to the people. So the idea then is that when we talk about electoral politics, it is those politically enforceable rights that must form the basis of our evaluation of mainstream politics and mainstream parties. So the elections that we speak of are the opportunity for us to assert the importance of politically enforceable obligations by the state. So there are, of course, very many different ways of understanding the relationship between the directive principles and the fundamental rights. There's also been a long jurisprudence in which the directive principles have progressively been brought within the writ of the fundamental rights through interpretation. But I think the most important part of it is that we must see it as politically enforceable. We must see it as political obligations on which we can hold a referendum on governments. We can hold governments to account. And of course, time and time again, we will have governments that want to have the figure of Godse in front of the parliament, or that want to reinstate the Manusmriti instead of the constitution, or that want to proclaim an emergency like in 1975. We dealt with them in 1975. People have political ways of dealing with them in later times as well. So I can never, in fact, underestimate the power of resistance. It has always shown us the way. Sometimes within a short period, sometimes it takes longer, but it will come. I mean, the time will come.
Thank you for pitching it at a very positive note. Especially, it's an apt ending for the discussion and the talk. I'm not seeing any questions as of now in the chat box, so I think we can proceed to close, because actually, Professor Kannabiran, they have another set of classes online starting from 2, the students.
Yeah. No, I also need to go for lunch.
Yeah. All right. Ruth, it's been a long afternoon. Jessica and Alicia, please take over.
As we come to the end of today's session, I would like to take this opportunity to express my heartfelt gratitude to Professor Kalpana Kannabiran for taking out time and sharing her knowledge with us. I would like to thank our convener, Dr. Maya John, and the WSC staff advisors for their constant support and guidance. I would also like to thank all the attendees who joined us for today's session. It's been a privilege. Thank you.
Thank you very much. Thank you, Maya.
Thank you once again, Professor Kannabiran. If you have any article which you recommend them as a follow-up on these issues, please share it with me. I'll circulate it. An article